All right. So, if I can get it working, it'd be great. Here we go.
Forced to relent to your husband's wants and needs, you finally removed him from the equation, all without implicating yourself. You worked hard to make sure it seemed like you were him from
Yeah.
the equation, all without implicating yourself. You worked hard to make sure it seemed like you were grieving. You cried throughout every memorial service, and you took great strides to make it appear as if you would stop taking care of yourself superficially. Although there were hiccups along the way, and you physically assaulted one of his closest relatives, you reminded people is a natural part of grief, and no one can really fault you for it. It would look terrible to attack a grieving widow, after all. You've moved on from the situation, gotten hold of the reasonably sized life insurance policy, and have even found ways to financially profit from his death, writing children's books about the situation and going on talk shows to promote your new brand, that of a mourning mother who only wants the best for her family. Though the investigation is still technically ongoing, you spent a significant time planning and making sure that none of this can fall back on you. And you know that even in the worst case scenario, people will believe that your husband was an addict, using people around you for drugs, because who would ever believe that you would do this? That was likely what Kouri Richins was thinking prior to her arrest on May 8th, 2023. And as more is revealed about the case, the more obvious her guilt becomes. Welcome back to another episode of Dreading, or if this is your first time here, welcome. Today we are going to be covering a major update regarding the Kouri Richins case.
Y'all, make sure you follow this guy, Dreading Crime and Psychology. Give him a, yeah, give him a shout out. And make sure you follow it. He's got some great content. I know I'm kind of using it, but people are gonna watch it anyway. I'm trying to send you to his page and get him some more subscribers. So almost at 1 million. Let's get him over the top. All right, thanks.
Case, and how she, while in prison awaiting trial, was found with a 6-page letter instructing her mom to tamper with witnesses in her case. Because this is an update, I will encourage you to pause this video here and watch our original one if you're unaware of the case details. I'll leave a link to the original video in the description box down below, as well as in the iCard for this video. I will also be leaving links to the creator who made the letters public, that being Defense Diaries on Twitter. As they are the originator of this content, please send them support for making this public. And with all that said, let's get into the letter. Walk the dog, but take vague notes so you remember. Sky is saying, even if the gummies have fentanyl in them, the prosecutor will say, I tried to put the fentanyl in the gummies so he would have them.
Oh my
Stupid, I know, but that's what she's thinking. All right, so pausing here for just a moment to discuss what she's alluding to here. Kouri's declared her innocence throughout the lead up to the trial, stating that even though between her and her husband, she was the only one to have purchased drugs in the past.
y'all don't y'all please don't. God forbid if you're ever a criminal defendant. And if you're in jail, don't send incriminating stuff in the mail. That will get you totally bombarded and busted. All right, they'll have you in there busting your Louis Vuitton prison suitcase every night. Do not do it. Keep your damn mouth shut. From the moment they say, we'd like to talk to you, say my name, give them your birthday if you want. You don't even have to really do that. Just give them your name. Don't lie to them. Don't give them a fake ID. Don't give them none of that. The second them cuffs go up, I want a lawyer. You are going to jail. You ain't talking your damn way out of it. You ain't doing nothing but going to jail. The second that happens, that cop has decided it, you're going to jail. Shut the hell up, get your bond, and get out. If you ain't getting out, shut your hell up, get in the cell, and don't talk to anybody about it. You can talk about a Braves game, you can talk about football games. You don't talk about your damn case, and you don't write letters like this. Holy mackerel. All right, I'm off the soapbox.
Last year that her husband was the drug addict. Though the police have found no evidence of him using illicit drugs, they did find that he regularly took THC gummies to help him sleep. To be clear, taking a weed gummy for rest and relaxation is in no way comparable to taking fentanyl, and the assertion that it is laughable. Kouri has encouraged the police to test the gummies throughout the investigation, telling them that they are proof of his addiction. And should they test the gummies, they will find that he was clearly into hard drugs, but her continued insistence that the police test the gummies for harder drugs would lead to any reasonable person.
And no one sells gummies with fentanyl. I mean, maybe the Mexicans do. I don't know. Maybe cartels do. But the last time I checked, I had never seen fentanyl sold on the market, even in fruitcake states like I think Washington. I think decriminalized uh, drug use or some small drug stuff. I can't remember. I ain't never seen it. It don't exist. This is like the dumbest thing I've ever heard. But this is what they do. They think it's great. They're the narcissists or the psychopath. Man, they ain't wrong. They know exactly what they're doing. They know how to do it. You can't tell them nothing. So, yeah, There you go.
to suspect that she'd done something to the gummies that her husband was unaware of. Again, out of the two, she was the only one to have recently purchased any drugs, and the police would have heavily investigated Eric's life. They would have gone through his bank records, checking his PayPal, Venmo, and other electronic cash apps. They would have talked to all of his friends, sorted through his contacts and social media, and the fact that they found no signs of him being interested in drugs is extremely telling. If he had a drug problem the way that she was insisting, there would have been evidence, but the only evidence that has been made public is against her. We will still test them though. However, she wants to link Eric getting drugs and pills from Mexico, so we need some kind of connection. Her private investigator is doing some research on the ranch cartel place Eric would stay at. Here's what I'm thinking, but you would have to talk to Ronnie. He would probably have to testify to this, but it's super short, not a lot to it. He will need to tell Sky at the meeting next week. Again, pausing here, there's no evidence that Eric has ever purchased illicit drugs for himself. However, he did go to Mexico for work, which would mean that he purchased a significant amount of things, and Kouri is now explicitly stating that she wants to use these business transactions, things that were 100% above board, to try and frame Eric as a drug addict. Moreover, the ranch he would go to had nothing to do with any cartel as far as I could find. Her saying as much is priming. Alright, back to the letter. Upon information and belief, just like they say. A year prior to Eric's death, Ronnie was over watching football one Sunday, and Eric and Ronnie were chatting about Eric's Mexico trips. Eric told Ronnie he gets pain pills and fentanyl from Mexico from the workers at the ranch. Not to tell me, because I would get mad, because I always said he just gets high every night and wouldn't help take care of the kids. There are pictures in my phone of Eric passed out on the floor or in the chair. Ronnie should have texts from Eric talking about getting high as well. Alright, so to pause again, this is pretty damning. But let's think about if this was true. Let's say that a year prior to Eric's death, he was talking to her brother and told him about his pretty severe drug problem. Why would Ronald wait for his sister to be in prison, awaiting trial, to tell the police about this? Why wouldn't he immediately make the police and Kouri aware that her husband had once sat him down to tell him about how he would buy drugs?
If it's true, they should be going to her lawyer, not anyone else. In fact, I wouldn't even write it. I'd have them come in and hand him the letter or talk to him. It, this is typical criminal clients, though. They don't think.
From Mexico. It wasn't as if Kouri was trying to keep the details of Eric's alleged drug habit a secret, as she had talked about it explicitly to the police and Eric's family, in a manner that they said was inappropriate. Had she had evidence that this happened, especially in another witness, she would have made that known to everyone involved, especially the police. But that never happened. So her writing out a time and location where someone was made aware of this habit and writing out what they should say verbatim is incredibly telling. Moreover, the pictures that she states she has proving Eric's drug addiction are once more extremely calculated. Eric worked extremely hard, and him falling asleep on a chair or on the floor is not proof that he was using fentanyl. But let's continue. Eric told Ronnie he keeps them in an allergy pill bottle in his work truck, so I wouldn't find them. Ronnie never told me about the conversation. Eric finally told me and asked if Carmen could get him some. Eric never wanted anyone to know he had an issue, especially get caught. He always wanted Kouri to go down for him. Again, this is incredibly damning, because now she is putting malicious intention onto her deceased husband, who she's still claiming accidentally overdosed. She is now implying that sure, he overdosed, but even in death, he wants her to go down for his murder, which is ridiculous. She is also notably recontextualizing her buying the fentanyl. Originally, she claimed she had no idea her husband was using hard drugs, and that had she known, she would never have allowed him near the children. Now that she is claiming that yes, she knew that he was using fentanyl and pain pills, and that even though she disagreed about his usage, she went out of her way to buy them for him, which is why they trace back to her and only her. This is a wild and frankly unbelievable change in the story, which only serves to make her look even more guilty. She could have stated originally that she knew her husband had a severe drug issue and had gone so far as to use some of her workers to get fentanyl. She could have brought the information to the police originally, but she didn't want to implicate herself. She also didn't want them to find out she had bought drugs from her housekeeper 2 times, and at the time prior to Eric's death, he had nearly succumbed to them. Alright, and back to the letter. When they traveled, Eric would put his drugs in Kouri's bag at the airlines right before they boarded. That way, if they were caught, Kouri got in trouble, not him. Once they got to wherever they were going, Eric would pull the drugs out of her bag, and it would cause a huge fight. She was pissed that he would risk her going to jail for his drug use. He just would laugh about it. Alright, so to be clear, this did not happen. This is a wildly unbelievable story. The very concept that he would sneak drugs onto her person, then take them off in front of her is outlandish. Furthermore, if he had a history of doing this, and this had happened more than one time, why would she continue to fly with him? Why wouldn't she just travel separately to make sure that he didn't frame her for drug trafficking? Why would she?
She could argue and say that she's somehow, excuse me, an abuse spouse, um, something of that nature, and that she had to do it because he made her do it. But it's that's just not a believable story. But it could be used as a defense. It's a plausible one, but it's not really believable.
She'd be okay with him traveling with their children. What's more, she continues talking in the third person at this point, as if this is what her brother would be testifying to, but he wouldn't know any of this. She's trying to instruct her brother on things that he would have no way of knowing. Even though he had said this in court, it would obviously come across as coerced. Let's get back to the letter. Kouri has never done any time of pills, didn't like them. Rarely, she would consume THC, only if Eric begged her, because it was a special occasion. Reword this however he needs to. To make the point, just include it all. The connection has to be made with Mexico and drugs. Ronnie will have the messages to prove Eric confided in him about getting high. It can be short and to the point, but has to be done. Upon information and believe, LOL. They never found pain pills or fentanyl in my house because he did it in allergy bottle in work truck, and Cody emptied it out work truck within a week, so they were never found. When you talk to Ronnie about this, meet up with him in person. I worry sometimes your house and phones are bugged. Alright, so if it was explicitly clear that she was breaking the law from inside of her prison cell and trying to get her mother to coerce her brother into giving false testimony, this clearly shows that that is what she was doing. Wow. Maybe drive down to SC and meet him after work without Bree. Sky has to make the connection between Eric and Mexico because that makes the most sense in her mind. If it's Ronnie's information and belief about the conversation over football, she can use that as a connection. Tell Ronnie, don't overanalyze it. It was a quick 2-minute conversation, lol. Tell him I need him to do this. Bring me home, and then we will get those damn bitches. Those damn bitches are Kouri's sisters. As a reminder, Kouri attacked his sister Amy following his death after realizing that Eric had left his sisters as the executor of Eric's trust and estate. Amy gave a victim's impact statement during Kouri's detention hearing, and although proof of her guilt had been on display for the entire day, when Amy spoke in court, that was the only time Kouri showed emotion, openly crying. But back to the letter. Also, please text Lotto or call. Tell him, do not next me anything about us doing things together, ever. Like church, skiing, trips, nothing that puts us together. It doesn't look good. We're so close to the end. Let's push through. Have the conversation with Ronnie before he meets with Sky. Then tell him to tell Sky at the meeting about the conversation. Hang in there. We're almost there. Love you to the moon. Take vague notes of all of this so you remember before you walk the dog. And even though that seems like the end, it appears to go on. I saw a commercial yesterday. Utah Mortgage Relief. Google them, please. It's for people behind on their mortgage. Can you see if they can help at all on Marissa's home, please? We have to get hers, yours, and Chelsea's taken care of ASAP. Try to go to that place in Camas. What about asking Lotto to do a loan solely in his name and not have you on there? I know he can do a home equity line of credit on his house in Hideout. Not sure if he would, but I know he has like $1 million in equity. Maybe he just doesn't know about HELOC, home equity. If he wants to help me, taking care of these loans is the most important. I don't give a shit about Yotels. Remember I told you, one way to get at Katie is going through my phone and finding a picture of her girls, even with the boys. Print copies and send them anonymously to different media companies. The fact that she's so angry at her sister-in-law and wants to attack them using their children is pretty disturbing. What does putting their children into the public consciousness do? What does essentially doxing the children accomplish, besides making you look like a monster? I'm sure had any media company or true crime reporter gotten these images sent to them, they wouldn't have made them public regardless. But the idea that she thinks that this is a plan of attack is obviously disturbing. She's more than willing to attack children, even though neither Amy nor Katie have done anything to deserve this kind of vitriol. But back to the letter. Obviously, don't email the pictures so it's not traceable. She would be livid if it got out to the public. You would just have to do it sneakily and be careful. She would try and trace it back to you. If not, no worries. Sky is having my girls do the first interview with Good Morning America. Please tell Chelsea to bring up that he, I assume she means Eric here, hasn't been to church in 13 years she has known him. And Eric would brag to her about how much he drank and did pills in high school. Tell Kelsey to say Eric always wanted Kouri to go down for him. For example, he would put drugs in her suitcase when we would travel together. So if anyone got caught, it was Kouri. He would put it in her bag right before they left the house so Kouri didn't know. Then, when we would land wherever, Eric would take them out of her bag and Kouri would be pissed and they would argue about it. So this is now the second time she is instructing her mother to coerce someone into telling this story, with the hopes that this would make her appear innocent. But there are a lot of holes in this narrative. Firstly, according to everyone the police interviewed who knew Eric and Kouri, they all agreed that the couple seemed incredibly happy. But moreover, they all stated that they never knew that Eric had a drug problem. According to the interviews they gave directly after Eric's death, they all agreed that they had never heard about Eric using anything stronger than THC, and that the hard drug use was not in his character. Them changing their original story only after Kouri had been placed under arrest would look highly suspicious. Secondly, how would they have known all these details? How would they know that Eric
May not be in his character, but it could be used to show mindset, or that he could have a proclivity for upgrading from marijuana to fentanyl. So that's something for a jury to decide. But it's not something I would want to give out to the world in a letter.
would place the drugs in Kouri's bag right before they left the home? If Kouri herself didn't know that, how would they know that Eric did it for the express purpose of trying to frame Kouri? And how would they know that Eric always wanted his wife to go down for his crimes? Would they claim that that is what Kouri told them? And if so, when had she supposedly told them all of this? Before or after she was arrested for his murder? Also, if you're in a relationship where you believe your partner is trying to frame you for a crime, you probably shouldn't be in that relationship, and you should probably, especially not, continue to travel with them. She continues, tell Kelsey to say how Eric didn't care and would just laugh about it and say, well, I can't get in trouble, as if it was okay that I got in trouble. Have Selma talk about Eric in Spain, not being able to drink, so he was looking for drugs the entire time, and explain the drink the waitress gave him, and how I called his doctor and went to the pharmacy immediately. So this story seems, at the very least, a bit more believable than the other two, and it's because she gave very few details about it. Let's say you want to remind your friend of a situation that you found yourself in a few weeks ago. Instead of delving into a long-winded story, going over minute details, you would say something like, remember that time we went to the store and we saw that one guy? That would be all you needed to say, because they would remember the details for themselves. But with every other story that Kouri is telling her friends to say, she gives them precise bullet points, telling them what they can or cannot say, and what she needs from them. So she continues on, have Allie talk about how the sisters have always been jealous of me, because anything they could do, Kouri could do better. Being a mom, college, stay-at-home wife, until she built $1 million company. A nice house, car, everything she had, they wanted. And that, everybody, is called delusional. Kouri wasn't a better mom, or a better wife, or a business person than anyone else. In fact, as her financial records show, she was in the red and struggling financially, but she did believe herself to be better than those around her. And when you think about it, that's really all that matters. And that belief has led her to being unable to look at the facts of this case for what they are. and see that even though she thinks that she's brilliant, her perfect crime has backfired in her face. She literally is unable to see that her own actions have led to her circumstances. In her mind, it's more believable that Eric's family is behind her being in prison than it is that she made a mistake. There is direct evidence that she killed her husband. From her buying the drugs used in the overdose, her immediately trying to profit off of his death with a golf tournament and a book, physically assaulting his family members when they inform her of his will, and more. But she continues on. This comes down to jealousy, money, and Eric's partying that they don't want to acknowledge, and sadly, an accidental overdose. Lastly, don't forget to work on the gun receipts. We want to file charges and let the prosecutor not do anything about it, to use in our defense. Will you buy a box of Crest white strips, open them up, put them in an envelope, and have Sky give them to me? You can tell her what's in the envelope. I'm sure she won't care. I'll make sure they can't be found in my cell. My teeth are yellow from so much coffee and tea all day. Frowny face. I love you, I love you, I love you, I love you. Hang in there. We're getting there slowly. You're the best mom in the whole world. I'm so lucky to have you. As mentioned previously, this letter would not be sent, only to be found in her cell during a routine search. After the letter was found and looked over, the prosecution set forth a motion for no contact. The state has begun to investigate this matter and found that this letter is not the first of its kind in this case. According to the motion, while on a video call on September 13th, 2023, Kouri held up a separate multi-page handwritten letter for her mom to read. The contents of the letter have not been made public and likely cannot be deciphered, as the quality of the recording is likely not great, but the letter probably resembled the one we just went over. This letter was not found in Kouri's cell and is believed to have been destroyed after the video call. As the prosecution has just started their investigation into Kouri's communication with her mother and other parties, it's likely that there are more letters like this one we have yet to come across. Communication between anyone in prison is always subject to monitoring, with letters coming in and out of prison being screened and phone calls being recorded. But it seems Kouri believed she had found a way around the system, choosing to show her mom handwritten letters via video call, knowing that those calls are usually listened to, not visually viewed. Prosecution has sent forth a motion so that Kouri can no longer be allowed to speak to her mother or anyone else on the witness list for the trial. However, based on the heinous things she wanted to have her mother do, I doubt that this will be the last time we speak about Kouri. Once more, thank you to the Defense Diaries for posting these documents for public consumption. Let me know what you think in the comments down below and what you think Kouri will do next. With that being said, have a great day and remember to stay safe.
This video was originally completed on September 17th. 2023, and posted onto our Patreon with the assumption that by the time we made it live, the information there would still be accurate and relevant to the case. However, more updates have come out, specifically about Kouri's actions while in jail, and we've had to supplement our coverage. So if this portion of our video feels as though it was added after the original video was completed, that's because it was. Whenever a person has been caught out doing something they shouldn't be, the immediate response is usually panic. You try to justify and excuse whatever it is you've been caught doing, and usually this immediate response results in you digging an even bigger hole for yourself. This is oftentimes why we see in interrogation footage that when a person feels cornered or agitated, it's because they feel the interrogators know that they are guilty, and they will change their story to a more outlandish version of events, saying that the victim was really the perpetrator. And that's exactly what Kouri's done. Seemingly, directly after she was made aware that the prison had found the 6-page walk the dog letter in her cell, Kouri spoke to her mother on the phone and claimed that the letter was not a letter at all. It was a small, 6-page portion of a book that she was working on. A few days later, she would repeat the claim to her brother. She claimed that the entire time she had been awaiting trial, she had been writing up a storm, making the best out of a bad situation. She has used her own dire circumstance as inspiration for this book, as it's a semi-autobiographical version of real-life events. The following is an excerpt from her phone call with her brother explaining this. They just kept saying it's a letter. It was never a letter. Like, it was part of a freaking book. Like, it was never a letter. It was never in an envelope. Or, yeah. So I was writing this book that basically, it's like everything that happened up until, like, the detention hearing, and then at the detention hearing, I actually get out of jail. So it's like a fiction mystery kind of book. So anyways, at the detention hearing thing, I actually get out and I'm on this mission to Mexico. Like, 60-something page book, and me and dad go to Mexico and we go to the ranch that Eric stayed at. And then we find out there's human trafficking. And then I don't know. And dad is trying to find out who sold it to him. And it was this guy in the kitchen. And then we're like, oh my gosh, we got it. We recorded it. Like, Ronnie, this is how ridiculous this thing is. I'm not kidding. So then dad's like, oh, it's the guy from the kitchen. Like, he just sold me some. And I was like, oh my God, there's human trafficking here. We got to go. Anyway, so we go back across the border and I get arrested because I was out on bail and I wasn't supposed to leave the state. So anyways, I write you and mom this letter from Mexico prison. And I'm like, okay, get me out. Like, you got to come. Like, all this stuff, like you got to tell them. And I I can't believe this is happening, oh my God. And then I get out of Mexico jail. Then the trial starts. And then I write about the trial, who's testifying. Like, they literally took those papers out of the story. So, okay, so that's about where that ends. This is crazier than the actual fucking murder. This is, this is insane. I hope you're all getting this because I'm barely understanding what she's saying. What I think is happening is that she's saying the letter only looks suspicious because in the context of her book, her self-insert character is acting suspiciously. Her character, who isn't her, but is her, is writing her mom from prison the same way she's writing her mom from prison in real life and instructing her to get the character of her brother in the book, who was named the same as her real life brother, wanting them to give false testimony to her lawyer, which is a super easy thing to mix up when you think about it. It's the classic case of a person being accused of murder, writing a fan fiction about their case, in which they leave the country and ask their friends and family to lie on their behalf. Clearly it's not real. Case closed. Let her go. Kouri then continues to tell her brother, it's a 65-page novel. They read the whole thing. And on the front of the novel, this is the worst part, on the front of the book, it literally says, quote, these are true events that have happened in my life, but the statements, the events, or this is surrounding, says something like that. These are surrounding the events of my life, but the statements, the events, the way it plays out, have been falsified for a fiction novel. It's called To Hell and Back, and none of this can be used against me because it's only a book. Again, this all makes perfect sense. It's like a work of historical fiction. Sure, the names, dates, and situation is exactly like the one she's currently in, where she's in jail for her husband's murder, and her lawyer is trying to establish a connection between her deceased spouse and any potential illicit drug use on his part. And sure, her character tells her mother to put pressure on her brother to give false testimony. But to think that she would do that? It's ridiculous. That's obviously her self-insert character, who has the same name and only exists in this book, that she chose to write in the style of writing letters to her mom in prison. So don't be fucking ridiculous. But is she done? No, she's not. She continues saying, that is why this is crazy. So they read the whole book, but only took out 3 pages that they sent to them, knowing that that's what it said on the front of it, knowing that I'm talking about going to Mexico with my dad that's passed away. Like, what? They pick and choose. And it even talks about, like, I said something about, like, I want Sky to pick me up White Stripes or something. Like, it's just something, I don't know. And then the thing is, like, so, like, I get locked down because I, like, got White Stripes in, and, like, I put, like, I don't know, some girl told me on something or something. All right, anyways. So she wrote a story where a character with her same name is in her same exact situation, and the story is seemingly written in the form of letters from jail to her mother, who she is instructing to witness tamper. But it's almost entirely a work of fiction. But within the letter, which isn't real, she asks her mother to give Crest White Stripes to her lawyer. Or, I'm sorry, her character's lawyer, who was named the same as her real-life lawyer. My bad. And also, upon search of her cell, the guards found the exact form of contraband she's asked for, which her lawyer seemingly brought in for her. But it's not real, it's mostly fiction, except for the parts that aren't. So all the things that make her look guilty are false, but most of the things in the book are true. Great. That's such an outstanding argument, it's really hard to find any fault in it. She goes on to claim that the whole 65-page document is with her lawyer, the same one who smuggled contraband in for her, and that basically this whole ordeal is a giant misunderstanding. She then explains. On the front of it, it says, like, the title, the characters, like, because I didn't change I on the front of it, I had, like, your name's Vinny. I don't know why, but I have, like, all the characters, and then what their names are going to be changed to. But, like, then I'm writing. It's, like, confusing, I think. Like, okay, wait. Who was Stella? Who was, you know what? So I use all of them and then go back and change them to the names that are on the front of the freaking book. And it even says, like, the title. These are the chapters. These are the characters. Nothing on this can be used against me. Like, this is all a mystery fiction book. Brilliant. I'd read it. Hell, I'm reading it right now. This is crazy. So Kouri realized writing a book like this would make her look guilty, apparently. And instead of not writing it or going through a small bit of effort that it would take to change the characters' names so they wouldn't be connected to her own situation, she made a legend for the front of the book. That way she could change the characters' names later on. Have we seen proof that this legend even exists? No. Does the story make any sense? Not really. But would Kouri, a woman who was accused of fatally poisoning her husband, lie to her own brother? Probably not. Like I said, case dismissed. Following the publication of the Walk the Dog letter, Kouri's lawyers filed a 31-page motion to enforce a gag order on this case and to hold the prosecution in contempt. According to the court record, which will be linked down below with all the other documents related to this proceeding, Kouri's attorneys were arguing that the letter has been publicized with the intention of hurting Kouri's credibility and tainting the jury pool. They also went so far as to claim that the letter was obtained through an illegal search of Kouri's private documents in her jail cell, more specifically, an envelope that was clearly labeled Sky Lazaro, attorney privilege. Following that motion, the defense then filed a 52-page motion to dismiss due to prosecutorial misconduct based on the Walk the Dog letter, which again isn't really a letter, and that they published it with the intent of making Kouri appear guilty in the court of public opinion. In response, the prosecution filed a 7-page motion to compel, which effectively breaks down the defense's arguments and plainly asks for another 60 or so pages of the manuscript. While we usually don't read court documents like this specific motion is so efficient at breaking down the defense's arguments that I feel it would be better to read it than to try and summarize. Again, this document will be linked down below. It reads, the state of Utah respectfully moves the court to compel the defense to produce the prosecution approximately 60 handwritten pages of paper, referred to by the defendant as a fictional manuscript. This document, handwritten by the defendant, was carried out of the Summit County Jail by defense counsel in violation of jail policy during the state's aggravated murder prosecution and its witness tampering investigation. The defendant has stated that the Walk the Dog letter is part of this fictional manuscript. The defendant described the WTD letter as part of, like, a 65-page freaking mystery fiction novel I've been working on. Half of the story is true, but, like, there's parts that aren't. This evidence is material and essential to the state's witness tampering investigation in preparation for trial. The state has met and conferred in good faith with defense counsel to resolve this dispute without court action. Ultimately, the defense refused to produce this material subject to a privilege review. So we mentioned this previously. Any letters or writing that comes in and out of the prison is subject to monitoring by the prison. Phone calls are recorded. Mail is read prior to it being sent, and incoming letters are looked over as well. We know this. But in order to circumvent that, it seems that Kouri was writing letters like this one, giving them to her lawyer to smuggle out amongst some of their legal notes, with the understanding that the Summit County police officers wouldn't look them over. She also held up notes during video calls with her mother, with the understanding that the person monitoring the video call was likely only listening and not watching. There are some documents that are considered privileged, but this book is not one of them, and it was her attorney's duty to turn said documents over when she became aware of their existence. They also are directly stating that they need the court to compel the defense to provide the rest of this manuscript, as the defense has refused to produce the material on their own, which is massive. The document then goes on to to state that the letter was found in a book in Kouri's cell, not in an envelope like the defense alleged, and that there were no other papers found with it. The document then reads, later that same day, defense counsel visited the defendant at the Summit County Jail. According to defense counsel, the defendant passed her an envelope labeled Sky Lazaro, attorney privileged. Trusting defense counsel and on the basis of her firm's solid reputation in the legal community, Summit County Sheriff's deputies did not search defense counsel or inspect the envelope for non-privileged material when the defense departed the jail. Defense counsel admitted to carrying the envelope and its contents, including non-privileged content, out of the Summit County Jail. Defense counsel explained she felt that she had done nothing improper because the sheriff's deputies chose not to inspect the envelope. Defense counsel did not explain why. In the subsequent 18 days, she failed to disclose the existence of the non-privileged fictional manuscript to the state, and only disclosed its existence when confronted by the state. Shortly thereafter, the defense and prosecution met, and they agreed that the defense would turn over the handwritten pages to a taint attorney, which is an outside attorney selected by the defense who would review the materials to see if it contains potentially privileged information.
I'm not sure that you would, in most rules, have a duty to disclose anything the client gives you. It's not the defendant or the attorney's job to procure evidence for the state. It is our job to have candor with the state or the judge, the court, and to present, for instance, an argument to exclude evidence that that case law which is counter to what you're arguing. That's called candor. So that exists. I'm not so sure why. Maybe it's their state. Why she would have a duty to essentially rat on her own client. That is an issue. Um, that I'm not sure what state this takes place in, but that's just my take on it.
However, 4 days after agreeing to turn over the documents, Kouri's lawyers stated that they refused to cooperate with the previous agreement. The motion goes on to explain why the entire manuscript, if it can be called that, should be turned over to a taint attorney. It states, the value of the WTD letter to preparing the prosecution's case for trial and investigating witness tampering in the case is self-evident. The WTD letter is the defendant's frantic, dishonest attempt to explain how Eric Richins may have obtained illicit drugs when all available evidence establishes that she, in fact, obtained the fatal fentanyl. The WTD letter illustrates the defendant's consciousness of guilt. There is every reason to believe that the remaining 60 pages of the fictional manuscript are as equally valuable as the WTD letter. Defense counsel's caginess and reversals on this issue do nothing to quiet this belief. The fictional manuscript is not privileged because it was not, by the defendant's own admission, prepared for her counsel or for the purpose of securing legal advice. The defendant repeatedly and adamantly refers to the fictional manuscript as a book, and a freaking book, as well as a fictional mystery book, a novel, a mystery novel, and a fictional novel. Defense counsel's unwillingness to disclose the general subject matter of the envelope's broader content only amplifies this indication. Accordingly, the state requests that the court or the taint attorney review the full contents of the envelope to determine what non-privileged material it contains.
Now that they could do a review. I hope y'all can hear me. I'm using my stupid Bluetooth earphones and mic. That you would do. You could say, look, I'll turn it over. We got to do it in camera and do it in front of the judge. And that way the judge can decide and the jury doesn't hear it. Okay? That's reasonable.
That must be provided to the state. This is one of, if not the most ridiculous defenses I have covered on this channel. While I can't be sure, I personally do not believe that there is a manuscript to turn over, which is why the defense has refused to comply with the agreement, or she could just write it really, really fast. Kouri continues to make things harder and harder for herself in this case, because even though the evidence against her is damning, her lawyers could have easily argued that the case was mostly circumstantial. They could have attacked the veracity of the evidence against her, attacked the credibility of the witness who Kouri allegedly bought the fentanyl from, and given an alternative form of events. But because of Kouri's own actions in trying to control the case, she has made herself look incredibly guilty. She told her mother to get her brother to lie for her on the stand. She tried to orchestrate her own media blitz from behind bars. In the moment when she was caught, she made up a new, even more unbelievable story that she was just writing a new story. I didn't expect to cover this case so soon after, and we will most likely be providing ongoing coverage via Patreon until this case goes to trial. But let us know what you think of this case and Kouri's story down below. Do you think that this letter is...
All right. Let's see if we can't see if there has been an update in this Richins case. That would be interesting. My guess is no. But who knows? Uh-oh. Nope. Still, yep. Still waiting. Ah, man, I'm telling you, that verdict, ah, that's not going to come back for the state. I'm just telling you. Let's see what we have an update. Oh, oh, this is an hour long. That's, yikes. Oh, this is 2 weeks ago.
Developing today, Kouri Richins will remain behind bars in the Summit County Jail until she faces a jury in her murder trial next year. Richins is charged with poisoning her husband, Eric, with a lethal dose of fentanyl in March of 2022. Last month, Richins and her defense team filed an appeal asking for her bail conditions to be reconsidered to allow her to be released from jail. Richins was originally denied bail in 2023 when she faced the death penalty. The state announced months later it would no longer seek the death penalty, leading Richins to request to be released until her trial.
As before, the severity of these sanctions, put plainly, of potentially dying in prison, creates a powerful incentive for defendant to harm herself or witnesses in this case, and to flee the jurisdiction of the court.
The judge also denied motions from Richins' defense team to split some of the charges and to seat 12 jurors for trial instead of sticking to 8.
Okay.
I will bet you a steak dinner that this entire hearing will be replayed and analyzed on numerous YouTube channels before the end of the day.
And that's exactly what we're going to do right now. We're going to dive into Kouri Richins' most recent court hearing as the alleged killer mom stands accused of poisoning her husband to get access to his money and then writing a children's book about grief to help their 3 sons cope. We've got major updates for you on some charges being dropped, how jury selection will go, and whether Kouri Richins will be released before trial. Welcome to Sidebar, presented by Law and Crime. Jesse Weber. This week, 34-year-old Kouri Richins was back in a Utah courtroom as her defense team argued several motions in front of the judge overseeing this case, Judge Richard Mrazek. Those motions addressed a laundry list of legal arguments and issues, so we're going to dive into all of them and get a sense of where we are right now in this case. So first, we got to give some background. Eric and Kouri Richins got married in 2013, and they have 3 sons together. Eric operated a masonry business while Kouri worked in real estate, flipping houses. You go to March 4th, 2022, and that is when Kouri says she fell asleep with one of their children, wakes up, goes to the bedroom where Eric was sleeping, but instead of finding him sound asleep,
Y'all go to Law and Crime and subscribe. Let's get them up. They're at 6.3 million, but we can get them higher. Got them? Hey, that's only fair, and I'm very thankful for being able to use it. Let's do that, okay? Cool. Let's hear the rest of this wacko story. I worked a case once where a guy had killed his girlfriend in 1990 in Augusta, Georgia, while in dental school, set it up to look like suicide. Somehow got away with it, only for in 2004 to do it again to his new wife. And I actually worked that case, and we ended up getting we were going to get a death sentence on both. We charged him in both. It's Augusta murder because DNA connected proof he did do it. And he did a very bad job setting up his other wife. That was Dr. Barton Corbin in Gwinnett County, Georgia. And that was right before I think he took a plea in 05. These kind of cases happen all the time.
she finds him dead, slumped over right on the bed. She said she made him a Moscow Mule before bed, that maybe he had taken a marijuana gummy. But according to police and prosecutors,
Hell is a Moscow Mule.
they say Kouri actually poisoned Eric. His autopsy showed that he had approximately 5 times the lethal dose of fentanyl in his system. The Richins housekeeper, a convicted drug dealer named Carmen Marie Lauber, had allegedly confessed to authorities that she supplied Richins with 15 to 30 fentanyl pills on 2 separate occasions, approximately 1 month before Eric died, and said that Kouri paid her about $900 each time. And you know what's also really chilling about this allegation in this story is that Eric allegedly previously claimed that Richins had tried to poison him on Valentine's Day in 2022. Gave him a sandwich, takes 1 bite, breaks into hives. He couldn't breathe. And that's not the only allegation, because there's another allegation that years before, Kouri had given him a drink while in Greece, and Eric became violently ill. And Eric allegedly told his family at one point, if something happens to me, check out Kouri. Now, this case caught the world's attention when Richins was arrested more than a year after Eric died, not only because of all the details that I laid out, but partially because it was revealed that following Eric's death, she had written a children's book about grief called Are You With Me? She even went on a local news station to talk about it. But again, months later, she was arrested. She was charged with aggravated murder, attempted murder, distribution of a controlled substance, insurance fraud, mortgage fraud, forgery. By the way, this Kouri Richins story, we have been trying actively to constantly be on top of, follow it, provide updates as it develops. And one of the reasons that we can continue to do that for you and make these kinds of shows is because of the support that we get from our sponsors, like Upside. Now, Upside's awesome if you don't know what it is. Upside is a free app that gets you cash back on daily essentials like gas, groceries, food. This is real cash back. It's money that appears in your Upside app that you can then transfer right into your bank account. Look here, I used the Upside when I went to dig for lunch, which, by the way, delightful. Claimed an offer on the app, paid with my credit card, followed the steps on the app, got cash back. So easy. I got 20% cash back. And you can use it at all different kinds of places, restaurants, convenience stores, gas stations. So to find out how much you could earn, click the link in the description to download Upside or scan the QR code on screen. But make sure to use our promo code SIDEBAR and you'll get an extra 25 cents back on every gallon on your first tank of gas. But now let's talk about what happened on this hearing on Tuesday. A lot of things to address. So the first thing that I'll mention is that all the parties had agreed to drop some of the charges. They agreed to drop the distribution of a controlled substance charges.
We are here on several motions. I don't have strong feelings about what order to do these in, but I have a proposal if you'll hear me out for a moment. First, the state's motion to dismiss counts 3 and 4 Ms. Nestor, any objection?
No objection, Your Honor.
And that is without prejudice, correct, Mr. Bloodworth?
Correct, Your Honor.
Okay. State's motion to dismiss counts 3 and 4, which is docket 703, is granted. Counts 3 and 4 in the third amended information are hereby dismissed without prejudice.
Now, no real reason was provided for why those charges ended up being dropped, but I will tell you sometimes prosecutors, they drop charges or agree to drop charges, maybe to not confuse a jury on the issues, or maybe they take out a weaker part of a case, because if there's a weaker part of their case, that could jeopardize their overall case, especially a murder case like this. Don't know that for sure, just generally speaking what we've seen in the past. Well, from there, the defense made arguments that some of the charges, talking about them, they should be separated out and addressed at a separate trial. They want the charges related to the Richins' finances, like insurance fraud and forgery. They want that to be severed from this trial. For example, Kouri Richins, she's accused of forging Eric's signature on an insurance application weeks before he died. And Kouri's lead counsel also wanted the attempted murder charge severed or thrown out altogether, saying there's no physical evidence whatsoever that points to Kouri trying to poison Eric on Valentine's Day.
So the slippery slope that you would have to slide down to connect a year prior to something she did in her business to obtain a loan, to somehow connect that to they've not made any allegations that there was a plan to cause death a year before. There's no allegation that she even had they've introduced zero evidence that there was a plan spanning back over a year temporally to her making a decision to take an act in her private, separate real estate business that wasn't even connected to her husband. I mean, basically, we would be trying two separate periods of time in history, two totally different sets of witnesses, two totally different sets of exhibits that have zero connection, other than the fact that it has to do with money. The argument being that, well, she did it. If she did it before, she must have done it again, right? And so that type of prejudice is just devastating to a defense, and it's based on zero evidence. There's no evidence of it. So to allow, I think the 403 almost kind of trumps the 404B argument in this case because of.
Hate when I can't get it to work. All right, so what they're arguing is that to allow this to happen would be an undue prejudice to the client. It would be so prejudicial that it would violate the rules of fairness, fundamental fairness in the trial, and it's not going to work.
The fact that there is no evidence of this. There is no evidence that Eric Richins on February 14th, that he ingested anything that was given to him by Kouri, that he had a drug, that he had controlled substances in his body, that he himself made statements that he was having an allergic reaction. He took allergic medication. It addressed the problem. And he had a normal day after he took a nap. So to make this leap and say that because he had an allergic reaction on a day 2 weeks before he died means that Kouri Richins tried to kill him is prejudice that we cannot surmount and has zero probative value because there's just no support. There's no support for it. So we would ask that severance be made on the 403 and 404B analysis. We would concede.
They're trying to say that it's not relative and that the probative value is not there for them to be able to even get it in the state. And she's arguing that there is no probative value in it, and it is prejudicial. So I'm gonna, I thought about this. I think the next video, I think I'm gonna go through the rules of evidence. I think that's what we should do. It's a little boring. You might like it, but it'll give you an idea of what the hell are they talking about. What are you talking about? Rule 401, 404B3, hearsay, or 403 for relevance, or even Rule 101, which just sets the boundary layers for the rules. But what's 702? What's the rape shield statute in the rules of evidence? All of these exist, and no one ever really talks about it. So, as boring as it may be, I think I'd like to go over there in the next video. Okay? FYI.
It's probably going to survive the statutory analysis.
So it's an interesting argument, right? Because where do you draw the line for saying two things are connected? When does the length of time between two events come into play?
The court determines that count 1, aggravated murder, and count 2, attempted aggravated murder, are part of a common scheme or plan because they involve a similar fact pattern occurring only approximately 17 days apart. In each instance, defendant allegedly purchased fentanyl from or through Carmen Lauber, allegedly administered it to Eric Richins through food or drink after purchasing it, and allegedly left Eric Richins alone, either by leaving the scene or moving to a different room. Those three circumstances, those three commonalities, are sufficient to determine that counts 1 and 2 are part of a common scheme or plan. The court is not persuaded that counts 5, 6, 9, and 10, that is mortgage fraud and related alleged forgery in June and August of 2021, meet the statutory requirement for joinder. They are not part of a common scheme or plan with the criminal homicide or the attempted homicide in March and February of 2022, respectively. And while the state argues that they are part of a direct relationship or form precipitating events for the attempted murder and ag murder that occurred 9 months later, court's simply not persuaded of that. There is too much temporal distance and too much dissimilarity. They're too different from the events that occurred in February and March of 2022. The court determines that counts 5, 6, 9, and 10 do not meet the standard for joinder under 77-8A-1, subsection 1. Under Rule 404B, evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion, the person acted in conformity with that character. However, this same evidence of a crime, wrong, or other act may be admissible for another purpose, a non-character purpose, such as proving intent, preparation, or plan. The court rules that evidence regarding the attempted aggravated murder on February 14, 2022, particularly in light of text messages that came after that date, in which defendant allegedly texts her paramour to the effect of, "I wish he would go away," or "if my husband would just go away," and on February 26, approximately, in which she contacted her source of controlled substances and stated she needed something stronger. Evidence of the attempted aggravated murder on February 14, 2022 is admissible for a non-character purpose of showing intent to kill Eric Richins and a preparation and plan on how to do so. Given the, in this court's view,
They're trying to, he's allowing it to come in the 404B3, which is prior bad acts of character. There are some ways around it. And what he's using is a common plan or scheme, or even maybe modus operandi, or um, um, something similar that would not be just the bad act by saying, she went and got this fentanyl, and that fentanyl is what killed him, and that getting the fentanyl was illegal. That's not enough. You can introduce it under this exemption he's getting in order to show a common plan of scheme, i.e., she went and got the fentanyl. She had this fentanyl, and then she used it in the murder by lacing his drink. So that's what the judge is putting together now. So they're going to lose being able to get rid of those.
Tissue of the defendant's alleged text messages between February 14 and March 3, and given the events on March 3, the court rules that the jury is most likely to make findings that the events of February 14 show defendant's intent and are probative of her preparation and plan to kill Eric Richins. The jury is unlikely to draw a general character or propensity-based inference that defendant's the person that tends to kill people, so she must have done it in March 3. Having walked through that analysis, the court denies defendant's motion to sever counts 1 and 2 from each other. Court rules that counts 1, 2, 7, 8, and 11 shall be joined for trial.
I know that was
For this is to say, okay, and it's actually a case. A bank robber comes in, and the federal government wants to say, well, you're a bank robber, aren't you? You've robbed banks. Yeah, I have robbed banks. What's that got to do with anything? You're wanting me for, tax fraud or possession of a firearm by a felon federally. And that they would try to introduce that, and the judge would sit there and go, well, and in the case law, bank robbers can tell the truth. If he's not convicted of a crime of moral turpitude, he can tell the truth. So that's one way to get around it as well. Okay. Um, so just because you have a bad act does not mean you can get it in to prove someone's lying. In the example I just gave, the the state would be seeking to say, well, you're lying, Mr. Bank Robber, because or Mr. Jones, because you're a bank robber. You have a prior conviction, 2 of them. Isn't that true? That doesn't prove he's lying. So that would not be allowed under the character evidence in 404B3. Or 443, yeah, 443B. 404B3, yeah, thank you.
a lot. So let me break down where we stand right now. So the mortgage fraud and certain forgery charges, they're going to be separated out. Those will be addressed at a different trial. Although I'll tell you, if she gets convicted of the murder charge here, I don't know if they're actually going to move forward with those other financial crimes, but we'll see. But what the judge decided not to do was not to sever the attempted murder charge from the rest of the case. So in the end, Richins is going to be tried next year for aggravated murder, attempted murder, as well as another forgery count and insurance fraud charge.
I don't know. Some of these, like, don't you have to attempt a murder to do it? You actually have to, I don't know, take a substantial step. I've never understood that. It, at least under common law, I don't know, 57 years ago, you would, it might be a lesser included. You charge them with the murder, and the jury may think, you didn't really prove that, but you did prove that she attempted to murder him, and they may come back with a finding of attempted murder. Nowadays, man, they just slap them all on there, and it's just not a big deal anymore, and it should be. The other problem we have is plea deals, plea bargains. Sounds like a great way to get rid of the case. Oh, it sounds wonderful. Except if I know I can only get you for attempted first degree assault or first degree assault, just no, not an attempt, first degree assault, I might as well charge you with, I don't know, let's say it was with a firearm. Let's say attempted murder. Because that way I know you're going to plead down to what I want, right? To get that first degree assault. That's what they're going to do 9 times out of 10. Maybe another charge lower. Maybe, or excuse me, first attempted. They would charge him with attempted murder. Yeah, for first degree assault with a deadly weapon, and maybe even get him down a little bit lower to just first, just do second degree assault. Or if there's a statute that says first degree assault without a weapon, which is unlikely. Um, it allows the state to just keep throwing spaghetti at a wall to see what freaking sticks. And it gives them unlimited ability to get a plea. They should have to come in, prove the damn case with the charge they allege. He tried to murder X. That's what we're seeking to prove. And if the jury wants to say you didn't prove that, but you did prove, uh, you know, assault, okay, that should be their ability. That's just not the way we work anymore. And yeah, that's unfortunate. But yeah, we'll keep up with this one. This is an interesting story. She's a narcissist. Apparently, it never got into it. Um, and we'll try to get into more of that later and see just how bad her narcissism is and whether or not she's a psychopath. Uh, Seemingly based on the letters that, hey, do this, we're going to make a plan, common scheme and plan to do this, and lie and manipulate her mother. I'm thinking she's probably more of a psychopath, period. So we'll see. I'd like to keep up on this one and follow up later on. Okay. All right, y'all. Thanks for hanging with me. Hit subscribe, click a like, and at least leave a comment. If you hate it, tell me to go screw myself. That's fine too. Just give it to me. All right, thanks.
Charges at the same